Good morning. Good morning, all. We are ready to start the day's proceedings. It's 29 minutes past 9. Please make sure that your devices are off. Thank you.
Good morning, Mr. Shaskalson. Good morning, Dr. Skuman.
Today's witness is Dr. Alberto Skuman. He is going to testify about flaws in the existing asset disclosure regime and possible reforms to that system that might assist in strengthening the capacity of the SAPS to resist infiltration by organized crime. I just want a couple of matters of housekeeping. There should be two files before the commissioners, a very short witness statement file that includes a witness statement and a report, and then a fairly large exhibit file that includes a series of articles and documents to which the report refers. And Dr. Skuman, do you have those two files in front of you as well? Good. Then if we can begin, Dr. Skuman, in the statement... sorry.
Dr. Skuman, will you be swearing or affirming? Please pull both mics closer to you and be seated centrally in relation to them, please. Thank you.
You comfortable? Great.
Yes, yes. So will you be, did you say affirm?
Sorry, say again?
Did you say you are affirming or swearing?
I'm affirming.
Affirming. Do you affirm that the evidence you are going to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Thank you, Dr. Skuman. If we can then start by just identifying that your very short witness statement, which covers the report, ends with your signature at the top of page 3. Can you confirm that's your signature?
That's correct.
And can you confirm that the contents of the short statement covering the report are true and correct?
That's true.
And then that the report, to which we will refer in some detail, represents your opinions based on facts that you believe to be true and correct.
That's right.
So if we can start then with the witness statement, in paragraphs, or from paragraph 2, you really describe your work and qualifications. And can I ask you to read paragraphs 2 to 5 into the record?
Okay. I am an extended term consultant engaged by the World Bank and task team leader for the World Bank's program supporting anti-corruption reforms in Southern Africa. I hold a PhD in politics from the University of Sussex. I have worked on anti-corruption programs for World Bank units across Southern Africa and South Asia. Prior to my work with World Bank, my work on anti-corruption and governance issues has included consulting for Transparency International, research and teaching at the University of Sussex in the UK, and research at the Institute for Security Studies. My work combines public policy research and technical assistance to inform public sector reform on topics including anti-corruption, civil service reform, and governance. This includes advisory support to a range of government entities in South Africa on anti-corruption reforms, including, among others, research for the National Anti-Corruption Advisory Council on strengthening the country's anti-corruption response. I am the author of a book on the relationship between political parties and the state in the Global South, with particular attention to the political administrative interface, state building, and corruption. I was previously a member of the Electoral Reform Consultation Panel, appointed by the National Assembly in terms of the Electoral Amendment Act of 2023 to advise on reforms to the electoral system in line with recommendations from the Zondo Commission to strengthen parliamentary oversight and accountability.
Thank you, Dr. Skuman. Now, we've asked you to present your views on the existing disclosure regimes applicable to senior officers within the South African criminal justice system, and to suggest some reforms that might assist to improve these regimes in combating corrupt infiltration of the criminal justice system. And you've prepared a report in response to our request. Can I just ask you to identify that report as Annexure A that starts at page 4 of this bundle?
That's correct, Annexure A.
And you refer to several reports in your report, and you refer to reports prepared by an initiative called STAR. Can you just explain what STAR is?
Sure. So the Stolen Asset Recovery Initiative is a joint work program between the World Bank Group and the UNODC, so the United Nations Office on Drugs and Crime. Together they work on a lot of issues around anti-corruption and money laundering, one of the issues being on asset disclosures and declarations. And so a lot of the work that we've done in South Africa around understanding and analyzing the financial disclosure system here is based on their work, and I've worked very closely with the colleagues within the STAR initiative.
Thank you. If we can now turn to the report. You start with an introduction which essentially describes the field and states the problem. Can I ask you to begin with by just reading paragraph 1 of your report?
Paragraph 1 says, collusion and conflicts of interest are at the heart of the issues investigated by the Madlanga Commission. Testimony before the Commission reveals systematic conflicts between the duties of public officials and their personal interests, where beneficial relationships with criminal actors have taken precedence over official duties. This includes the abuse of positions of authority to intervene in and obstruct investigations, the disclosure of confidential information to criminal actors, and the manipulation of procurement processes to direct contracts to associates, each underpinned by an expectation of reciprocal benefit, whether in the form of gifts, payments, or gratifications channeled through family members and private business interests.
So would it be fair to say that there are really that what you speak to is a problem where, through corrupt infiltration, organized crime has been able to gain purchase over the SAPS through 3 different types of quid pro quo that come on the other side. The first being abuse of authority to intervene and obstruct investigations. The second being the disclosure of confidential information to criminal actors to assist them, and the third relating to procurement processes. You're nodding your head there.
I think that's correct. I believe that's the evidence before the Commission.
And that, of course, speaks to a serious failure in the institutional framework for detecting and combating corrupt infiltration of the SAPS. Again, I must ask you when you agree to say yes as opposed to nod your head, because we, at a later stage, will have a written record.
Sure, I agree.
So can we speak to what that institutional framework currently comprises. And in paragraph 2, you talk to that, and you identify the elements within the public service regulations and SAPS regulations that are relevant in this regard, or what they're targeting in this regard. Maybe if I can ask you to pick up there in paragraph 2 and well, to highlight what the system is designed to do.
Sure. So within the current framework, in terms of the public service regulations as well as the SAP's own employment regulations, there are a series of measures and mechanisms in place intended to deal with conflicts of interest, to manage integrity within the public sector as well as SAPs. And so that includes mechanisms around financial disclosures, so preparing forms stating your financial interests and assets. It includes protocols around conflict of interest management. If a conflict arises, what is the process in place to determine how to deal with that? A series of other measures, such as protocols around gifts, the limitations on the value of a gift and when it can be received, how it should be reported, prohibitions in terms of outside remunerative work, permissions that have to be granted, and process around that. So collectively, a series of regulations around ensuring that public sector officials behave themselves in line with public sector values with the intention of preventing misconduct, corruption.
Now, your report is in large part focused on identifying where the existing system is failing and what its weaknesses are. In paragraph 3, you essentially set out the topics that you're going to be addressing in the report. And can I ask you to pick up there, just providing essentially a roadmap to where we will go today?
Sure. So the note starts by talking about corruption prevention as a concept. So this is something distinct from what we often focus on in terms of investigating and prosecuting corruption. So when we talk about corruption prevention, it's all of the measures that I've just mentioned around how do we manage public sector integrity, how do we avoid conflicts of interest. So I start by explaining why this is important in the public sector, why we should care about corruption prevention, and why it matters. The rest of the report looks at corruption prevention, in particular in SAPS, but as applicable to the broader public sector. And a lot of this is through the lens of the financial disclosure system, which forms a very integral part of the corruption prevention architecture. A lot of the accompanying processes build on the financial disclosure system. When we talk about lifestyle audits, lifestyle reviews, conflict of interest management, a lot of this relies on the initial disclosure forms. And so it is very reflective of the issues that we have within corruption prevention as a whole. So we focus on financial disclosure form and the accompanying institutional framework, the sanctions attached to that, as a lens through understanding some of the deficiencies in the current framework for corruption prevention.
And then still giving a roadmap to where we're going, in paragraph 4, you talk about areas of reform on which you're going to focus. Can you again highlight those?
Sure. So effectively, and this is what how the report is structured, but the 3 areas of reform that I'll talk about is one about the financial disclosure form itself, the particular assets and interests that are required to be disclosed by public officials. The second point being around the institutional and operational framework for how we manage financial disclosures, as well as corruption prevention more broadly. And then the third point being around the sanctions in place. So the questions of consequence management, which are, of course, very important for closing the loop. And I think all of this, effectively, as we go through the report and discuss today, I think all of this, what this points towards, is broader restructuring of the anti-corruption architecture, both from a policy regulatory perspective, but also thinking about the necessary institutional reforms to address some of the deficiencies in the current system.
If we then start getting to the substantive topics themselves, you deal broadly with the topic of corruption prevention from paragraph 5. And can I ask you to read paragraph 5, or not, if you don't want to read it, to speak to what paragraph 5 talks to?
Let me speak to paragraph 5 so we can keep this as a discussion. So I've already mentioned corruption prevention as a concept, as something distinct from investigating and prosecuting corruption. And we can essentially understand this as two types of prevention. The one being deterrent prevention. So it's about raising transparency, ensuring that we have mechanisms in place to ensure that it is more difficult to commit corruption and to get away with it. So in this context, we would talk about things like the financial disclosure system. We would talk about corruption risk assessments and hardening the system against corruption. We'd think about transparency. So deterrent factors, it's about ensuring that it's more difficult to get away with corruption, it's easier to detect it, and so it places external pressures on officials to behave with integrity. The second aspect of prevention that we can focus on is around your intrinsic motivations. So here we talk about constructive prevention, and essentially this is the focus on ethics training, on how you as an individual think about how you conduct yourself, your views on corruption. So when we talk about this kind of corruption prevention, we're more interested in the norms and values, the organizational culture, and how we can change that. So both of these form a very important part.
You identify the regulatory framework governing corruption prevention in South Africa with reference to the SAPS in paragraph 6. But you make the point in paragraph 7, which I'd like us to dwell on, that one needs to look at the implementation of the framework, and one needs to look at how SAPS itself perceives the way in which it's implementing its framework. And you refer to the annual reports in 2023-24 and 24-25. Those reports are in the, or extracts from those reports are in the exhibit bundle. 23-24 is at page 4, and 24-25 is at page 9. And maybe, I mean, they're very similar, so I don't think we need to go through both. Maybe if I can ask you to focus on the more recent report, 24-25 at page 9, and to highlight what you think is relevant in that regard.
Sure. So page 9 of SAPS's annual report speaks to the mechanisms, their internal mechanisms for reporting fraud and corruption, and how they deal with these issues. And there's a particular section, a table there that deals with prevention, and they mention the measures carried out by the Risk and Integrity Management section. They mention ethics workshops, minimum information security standards, the disclosure of financial interests, restrictions around applications for additional remunerative work. They speak to security screening, declarations around gifts and sponsorship. They speak to their measures for detection in terms of polygraph testing, etc. And so what we see on paper, I think both in SAPS's annual reports and I refer in the same paragraph later to the Minister of Police's response to a parliamentary question, we see this long list of mechanisms in place to support public sector integrity and support integrity in particular within SAPS. And so it would seem that all of these mechanisms are in place on paper, all of the standard requirements that one would expect. Now, the question that I pose to the Commission is, having heard the testimony so far and hearing this list of mechanisms in place to prevent corruption, it seems to me that there is a disjuncture between what is on paper and the impact that we see in the real world. And we can get to that further, Matthew.
Thanks. That is obviously what we're going to spend most of our time on. But before we do that, maybe if we can take that ministerial answer and which you quote at the foot of page 7. There was one point that that struck me about it. I mean, the answer talks about a range of detection measures, including lifestyle reviews, conducted through SAPS's analysis of a number of integrity control measures, such as financial disclosures, gift management protocols, performance of remunerative work outside SAPS. That determines red flags. And then anomalies which are detected are referred for further lifestyle investigations, and when necessary, forensic auditors are engaged for lifestyle audits. Do you know how many lifestyle audits have been done in the last 5 years?
My understanding is that no lifestyle audits have been conducted within SAPS as of yet. There is a later parliamentary question that I believe came out, I think it was last week, where the acting Minister of Police indicated that they were still in discussions with the SIU to second officials to SAPS to do these lifestyle audits for them.
Can I take you to that question? It's actually at page 11 of the exhibit bundle. Sorry, page 78. I've got the wrong question. Page 78. And the critical information in the answer is in the table that is at page 79.
Sorry, Matthew, could you repeat that?
79. The table in page 79 gives you the statistics of what's been done where.
79, right, yeah. Sure, so that's correct.
So before we go to the schedule, should we not actually read the question onto the record, the question itself?
Yes, Chair, that makes a lot of sense. Can I ask you to read what the question was and what the answer is, so we understand what the Minister was answering?
So the question was whether any lifestyle audits have been conducted on senior leadership within the South African Police Service in the past 5 years. If not, why not? If so, what A, audits were conducted, B, ranks were subjected to such audits, and what were the outcomes of the specified audits. The second part of the question is whether the SAPS has approached and or engaged the Special Investigating Unit or any other external body to conduct independent lifestyle audits of senior police leadership. If not, what is the position in this regard? If so, what are the relevant details?
And maybe we can start with the answer to 1A. Page 78.
So on page 78, it says that lifestyle assessments, including reviews and investigations, were conducted within SAPS. And I think this is important to be specific about, that reviews and investigations are separate from lifestyle audits. At a later stage within the report, I explained the difference, but effectively what SAPS has currently performed is just the reviews and investigations.
And in one subparagraph A underneath one, I think your point is made, albeit
Yep.
in the fine print, as it were.
So it says, based on the lifestyle investigations conducted for senior management service members, no cases escalated to full lifestyle audits during the period under review.
And the period under review in the question is the past 5 years.
That's correct.
Dr. Skuman, may I just understand, what is a lifestyle review and what's a lifestyle investigation?
So a lifestyle review is something that is conducted by an ethics officer within a line department. So a review is based on the financial disclosure form. It looks at the assets that an official has reported. It compares that to an official's income, and they determine whether they believe that is consistent. If it's not consistent, they can refer that to the head of department for a lifestyle investigation. Now, this is the next level of assessment. The lifestyle investigation would be conducted by an investigator, so somebody who would have a bit more expertise in conducting these kinds of investigations. This would look at additional sources of information to determine whether there is potential unexplained wealth, to determine whether an individual might be receiving income from potentially nefarious sources or corrupt sources. So the lifestyle investigation, that would include looking at bank records, that then goes into looking at a person's qualifications. It would look much greater scrutiny of the form and trying to back up what is there, and potentially looking to see if a further kind of criminal investigation would be warranted.
And how does an investigation differ from an audit?
So an audit would be the next stage. An audit is once you involve a certified auditor, and so they would apply forensic audit techniques. So a lifestyle audit would essentially be a more sophisticated type of investigation being conducted.
Thank you.
Now, in your answer to Commissioner Baloyi, you've essentially anticipated what you say in paragraph 9 of your statement on page 9. Is there anything further that you would want to highlight in relation to the distinction between lifestyle reviews, lifestyle investigations, and lifestyle audits?
I think one of the things that we haven't discussed in depth in terms of the response is that within SAPS, every year there have been these lifestyle reviews conducted. And some of them have led, in very few cases, to lifestyle investigations. In each case, they have been cleared. And I think this is an important part of the story to tell, that these are being conducted at the lifestyle review investigation process, but not necessarily turning up any results. And so I say on page 9, at paragraph 9.2, between financial year 2021, 2022, and 23-24, no SAPS officials were referred for lifestyle investigation. In 24-25, 5 of 823 SMS members underwent lifestyle investigations, and all were cleared.
And you make the point in paragraph 9.3 that the final stage, lifestyle audits, involves a cost. Can you amplify that? Because that may also explain part of why they don't happen.
Sure. So as I mentioned, the lifestyle audit framework, so to speak, that escalates from reviews to investigations to audit, it includes varying degrees of specialty. So initially we start with ethics officers. These are often more junior officials. They're not necessarily specialized investigators. Your lifestyle investigations would ordinarily be conducted by an investigator within the department. So in terms of the minimum anti-corruption capacity requirements, so this is a directive from Cabinet which requires every line ministry to include an internal investigation capacity. This is not always something that is fully functional. In many cases, line ministries don't necessarily have all of the capacity they need to conduct such investigations. When it comes to the lifestyle audit process, this is a very particular skill set as it requires auditors. So this is beyond your potential. You might have internal auditors within your department, but it is not something that they would be conducting, these kinds of audits. And the lifestyle audit framework established by the Department of Public Service and Administration specifically states that lifestyle audits should not be conducted by internal auditors. So in the current framework, in lieu of this internal capacity to conduct lifestyle audits, what is happening is that departments are outsourcing these audits. So they would get an external company to conduct these lifestyle audits for them based on the financial disclosure records, or they would enter a secondment arrangement with a special investigating unit. How this works in practice is that these SIU officials are seconded to the department and effectively no longer function with the SIU's powers. So they are functioning as if they were a departmental official. What that practically means is that they no longer have the same mandate, access to resources that they would ordinarily have as an SIU investigator. And so one of the challenges, I think, within the current framework is both the powers related to the lifestyle audits, because this is a question of access to financial records. In the current system, to conduct a lifestyle audit, you would rely on the auditee, so to speak, the declarant, the individual under investigation, to submit their own financial records to the auditee. The challenge with that being is that somebody could very well hide some of their bank records. They can determine what to send somebody. If you have an authority with access to financial systems, they would much more easily be able to see the full scope, the full range of accounts with financial institutions. They would have much more access to the government databases and systems to be able to conduct a thorough audit. But what I should also mention in terms of the cost, so I mentioned here, and this is a cost that has been shared in public domain, of a single individual being audited, that it would cost something between 30 to 50,000 Rand. And the reality across the public sector right now is that these lifestyle audits have turned up very little. And I don't think it's necessarily an indictment of the lifestyle audit process itself. I think it is a noble objective. It is an important part of the anti-corruption response. I think the issue is with the current approach that we use, some of the gaps in our approach in terms of the financial disclosure reforms, what officials are required to disclose, the institutional framework around how these lifestyle audits happen. So this speaks to the issue of the powers that I've mentioned. And then the final aspect being the question of consequence management if something were to turn up. And so much of what I would speak to today is around those 3 points, but highlighting here the issue that these are very costly, but currently largely ineffective.
Can I just clarify, because it is a point that you've made, but it seems to me to be a particularly important point, which is that whether they're conducted by private auditors or by SIU auditors seconded to SAPS, the persons conducting lifestyle audits have no statutory powers to collect information from financial institutions. So they depend entirely on information that is voluntarily provided by the person they are auditing.
That is my understanding, that's correct.
And at the moment, the system only reaches this lifestyle auditing stage after it's gone through, after a red flag has been triggered below it. There's no system of random auditing that takes place.
So the expectation with the escalating audit or lifestyle review process is that you start from the baseline of the initial review to turn up red flags. It goes for further referral for more in-depth investigations. And so this would, if there are suspicions in a particular case, this would escalate to the lifestyle audit phase. Within the current context where there are a lot of concerns around corruption and misconduct within the senior management service, what a lot of entities have opted to do is to go straight to the lifestyle audit process, to have blanket lifestyle audits for the senior management service. In some ways, I think in international examples, this is irregular. It wouldn't be normal practice to conduct blanket lifestyle audits. Ordinarily, a lifestyle audit is something that you do when you have good evidence that there is some kind of concern around an individual that warrants this kind of more in-depth investigation. In many cases, a full lifestyle audit in other jurisdictions would include speaking to their associates, determining, who they have business dealings with, doing a much more thorough investigation. This blanket approach, I think, is reflective of the fact that the financial disclosure system, the verification, the lifestyle reviews, so far have not been turning up anything. But at the same time, we know from experience, we know from media reports, we know from what we see in commissions such as yourselves, we know that there are these things happening, but they're not being detected. And so the current approach has been to institute these blanket lifestyle audits across the senior management service. But as the advocate mentions, what you'll find in many jurisdictions is that the lifestyle audit process is more driven by good evidence of a particular case where you might want to do a much more in-depth investigation. Page 80 to 81, the final paragraph of page 80 says, engagement processes with the Special Investigating Unit have been initiated. However, the secondment and full operationalization of the support remain in progress. In addition, all senior management service members are currently undergoing revetting. If I can also point to the paragraph in the middle, just below the table, it's highlighted with a 2. It says, yes, the South African Police Service has formally engaged the Special Investigating Unit to assist with independent lifestyle audits. The National Commissioner signed a formal request on 5 August 2025, which was submitted on 6 August 2025, requesting the secondment of SIU personnel to support SAPS in conducting lifestyle audits. The parliamentary question in question was reply to this response that I'm reading from now. This was early July. I think the exact date may be on here, the 5th of June. So as of the 5th of June, the SIU has not yet been seconded to SAPS to support lifestyle audits.
That's 5th of June 2026.
26, that's correct.
Now, we're going to get in due course to the problems of the disclosure form at the root of the problem. But before we do that, you make an important point in paragraphs 10 to 12 about the limits of. I'll ask you to highlight those points.
Sure. So you'll recall at the start of my presentation, I discussed the different approaches to corruption prevention in terms of deterrent prevention and constructive prevention. So essentially, the difference being whether we focus on rules and mechanisms to make it more difficult for people to get away with corruption, whether we more strongly enforce compliance with the rules, or whether we focus on trying to build integrity, so to speak, the softer norm change aspects of corruption prevention. And what I speak to in paragraph 10 and 11 and 12 is about where we should place the emphasis effectively. Do we focus on an idea of building ethics and training people and encouraging them to engage ethically? Or do we strengthen the legal and regulatory mechanisms to compel compliance with the rules, raise the standards? And in paragraph 10, I speak again to the SAP's annual report, in which they have a performance indicator related to this question of integrity and professionalism. And there are some figures there that reflect the progress on this particular indicator. And this is based on internal workforce survey that was conducted to determine how SAPs see professionalism within their own organization. And I'll read here from paragraph 10 on page 10. And it says, I'll start in the middle, that it says the latest SAPS survey conducted in 22-23 found that only 24.4% of SAPS officials agreed that the police conduct themselves professionally, while 31.6% agreed that the police do not abuse their power. And so the point that I want to make here is by SAPS's own internal surveys, the way most people see their own organizational culture is that they don't see it as an institution with great integrity, that they recognize that their colleagues do not behave the way that they should. In many cases, they understand that misconduct is rife. And so when we compare this to some of the initiatives mentioned in terms of advocacy programs, in terms of campaigns, in terms of statements to say that we do not tolerate corruption, it's very difficult to imagine how a message like that cuts through when people's everyday lived experience is their colleagues engaging in misbehavior. And so to turn around an organizational culture like this, you cannot solely rely on messages about ethics and integrity. What you really need to do is focus on strengthening these other types of controls around your legal and regulatory mechanisms, ensuring that you have the right policy framework, the right controls in place, the right measures for detecting this kind of misconduct to bring people into line. And the purpose of that is that over time, when you have this kind of rule-based compliance, people realize that this is what has become the norm. That you see your colleagues, they're all filling out their financial disclosure forms correctly. They're treating citizens with the kind of respect that they deserve. So it's much more difficult for you to fall out of line with that. So once everybody starts complying with the rules, ethics starts developing in and of itself over time. And I'll refer to here, I think often about, there's a professor at the University of Oxford, a gentleman by the name of Christopher Stone, who's done a lot of work looking at organizational turnarounds, particularly in law enforcement, to deal with corruption around the world. And he always makes the argument that what you find in most organizations is a large middle group of people that are neither extremely ethical nor unethical. This is a group of people that go along with what the cultural norm is. They will turn a blind eye towards misconduct because they don't want to get involved. They will follow the rules and behave ethically because that is what is required of them. And so he makes the argument that to switch the organizational culture, to win over this middle that you can be persuaded, it's about these types of mechanisms to bring integrity back into the norm through rule-based following. And that is the kind of approach that I think that South Africa should be focusing on, I think particularly within SAPS, but as the broader public sector as well, to restore ethics, to not just focus on issues such as training and promoting ethics, but really thinking about the types of controls that are in place to enforce discipline and ensure that there are consequences for misconduct.
Before you proceed, this survey that you speak to, that you've read here, what does it measure? Does it measure financial behavior or just generally the corruption in general? professionalism? What exactly was it measuring?
So I don't have the exact question that was posed. This comes from the SAP's annual report. And so I've used their particular wording around the percentage of officials that agreed that their colleagues, the police, conduct themselves professionally and ethically. That was the question from the SAP's report.
Thank you.
And just to amplify the point that you have been making, that you need a system that properly enforces rules if you're going to win over this middle ground that you speak to. Can I ask you just essentially to read paragraphs 11.1 and 11.2, which really speak to why that's necessary?
Sure. So 11.1 says, where corruption is embedded in institutional culture, ethical appeals tend to fall flat because the system itself rewards corrupt behavior and punishes those who resist it. The next paragraph, an individual with strong personal ethics operating inside a structurally corrupt system is largely powerless, lacking the necessary institutional framework to support ethical behavior and facing continued pressure to turn a blind eye to misconduct. Both the Zondo Commission and evidence before the Madlanga Commission provide such examples of ethical officials under huge pressure and constant harassment from colleagues engaging in misconduct.
So if we can move now to where you see the specific technical problems in the current system. And can we start at paragraph 13 on page 12, where you're talking about financial disclosure as the cornerstone of integrity management?
Sure. So the starting point of the integrity framework to a large extent is the financial disclosure system. And the reason why I say this is that a lot of our other controls build on this or build around it. So when we speak to issues around conflicts of interest, the way that we currently determine whether an official has current conflicts of interest is through the financial disclosure form. It is the companies that they disclose on their forms that we then check whether they are on the central suppliers database, whether they might be engaging in business with the state, or whether this company might be involved in a sector, for example, that might pose some kind of conflict of interest. It's the same with the lifestyle review and the lifestyle audit process. All of this builds on the initial disclosures. So it is really a critical component, and it has such downstream effects when we get this wrong, when there are omissions in this initial form, areas and blind spots that we don't check. Down the line, when we're trying to understand an individual's potential conflicts of interest, if we don't know what companies they themselves are involved in, if we don't know what companies their family members are involved in, we're much less able to determine what an individual's conflicts of interest are. It's much more difficult to put in place preventative controls so that they divest from those conflicts, or that we find some kind of way to get around that.
And then in paragraph 14, you start detailing some of the problems that you see in the current disclosure regime. Well, paragraph 14, you just make the point that there are different disclosure regimes across the public service generally. But in paragraph 15, you identify what you see as the design deficiencies. And can you highlight these?
Sure. So let me start with paragraph 14, because I think it's an important point to make. I have been speaking a lot about a financial disclosure system as if it is one framework within South Africa's current institutional context. The reality is that there are many different disclosure frameworks. The members of parliament have a distinct framework where they are required to disclose their interests. The executive has a separate framework in terms of the Executive Ethics Act. The Judiciary has a separate framework and requirements in terms of the Judicial Services Commission Act. Local government has a different framework, both for councillors as well as officials within local government administration. And so effectively what happens is that you have inconsistent standards across the board, that some people are held to higher standards maybe, others are required to disclose less, or their disclosure forms are not publicly available. And the effect of this, I think, is that both that you have inconsistent standards, but also that the kind of capacity that one needs to have a functional system of verification and follow-up investigations is effectively dispersed across all of these various institutions. And it leads to a lot of inefficiencies. And part of the issue is when we talk about investigations, one of the clear challenges that we know that we have, that there is in South Africa, is around investigative capacity. We see some of the challenges with the speedy investigation of cases. Within the current framework, where we have this mandate dispersed across so many different places, what we also then do is disperse all of this capacity for investigating, or we require lower level officials, not to diminish them, but officials such as ethics officers to be conducting the initial verification and review. And this is a function that they might not necessarily be specialized in. They might not have the particular skill set, the capacity to understand how to conduct a proper investigation in order to prepare it potentially further down the line for a criminal investigation. And so one of the inefficiencies that I speak to at a later point is around the institutional framework for this. And a large part of that comes from this initial issue that we have with the dispersal of this mandate and the various different types of systems that we have. In paragraph 15, I start speaking at a high level to the core challenges that we have in the design of the financial disclosure system. And this is really just an overview of the rest of where we're going today. And here I speak to some of the core gaps that include gaps in the disclosure requirements, leaving loopholes to conceal assets and interests, fragmentation of the institutional framework for collecting and verifying disclosures, creating inefficiencies and undermining effectiveness, and the absence of a credible sanctions regime for applying consequences to non- and false disclosures. And so this is essentially the framework that we'll speak to in the subsequent sections.
So the first gap in the disclosure requirements that you identify is, paragraph 17, where you talk to the exclusion of family members from disclosure obligations. Can you highlight that?
Sure. So the current form and disclosure requirements only apply to the individual, whether that's a public servant, elected official, etc. In each of these cases, it is only you as a person. We know that this, from international experience, we know that this is not sufficient. One of the easiest ways of concealing your financial interests and wealth is to place these same companies in the name of your immediate family members. And so it doesn't really take that much to hide these assets in the current framework. It doesn't require a whole lot of sophistication even to put a company in your wife's name that might be doing business with the state, or in the name of your children, to put a car or a piece of property that you've been given as a gift to rather register that in somebody else's name. And part of the challenge with not extending these requirements to your immediate family members is both the concealment of these assets and your financial interests, but the effect that, downstream effect that has, for example, on managing conflicts of interest. If we, as a, say, for example, as a public service commission or line ministry, if we're not aware of your wife or husband financial interests in, for example, let's say medical supplies, and you work in the Department of Health, that can potentially pose a very direct conflict of interest. And in the current regime, that is not something that we would be directly able to consider, because we don't require that kind of disclosure to be made in the disclosure form. There might be other places where you are required to report ad hoc conflicts of interest in a more formal way, but separate to these requirements. But the form currently is limited in this regard. And I mention this also because this is, as I've said, a very, very common issue that you see internationally. You see it locally as well. And so the way to get around that, what you'll find is in many countries that they've started introducing requirements to also extend these kinds of disclosures to your immediate family members.
And a related problem you highlight in paragraph 18 is that it doesn't deal with beneficial ownership. Can you amplify that?
Sure. So let me start by explaining what we mean by beneficial ownership. What you'll often find in grand corruption cases, in money laundering cases, in tax evasion cases, is that actors are sophisticated. They will put their financial interests, their business interests, their companies in complex legal structures. You have a company that owns a company that is put into a trust, etc. And so this starts blurring the lines when you're an investigator, and starts making it much more difficult to determine who ultimately benefits from this asset or this company, who has direct control over it. And so commissioners will remember over the last few years, South Africa has been working on leaving the grey list in terms of the anti-money laundering requirements and the standards set by the Financial Action Task Force. And so a lot of the amendments introduced as part of those reforms were around introducing beneficial ownership registers for companies, for property, and even in the case of trusts, determining who is the ultimate beneficiary of an asset. And so this is a very relevant concept and issue when we talk about the disclosure of your financial interests and assets. Because if we don't require an official, and we don't make this clear that an official needs to disclose their beneficial ownership and interests in companies or property, effectively what we're leaving open again for them is to just use some kind of a nominee or intermediary structure that they can transfer all of those funds in, put it in a trust, or find some kind of way that an official doesn't have to declare these assets or interests because they're not in your official name. So purely by having this small arm's length of distance between you and an asset, you can prepare your disclosure form entirely correctly. You can fill it out without having to worry about all of those things that you haven't disclosed, and you'd be following the rules. And I think that that's part of the challenge here, that we've left open, I think, both with the family members and the beneficial ownership issues, we've left open two of the biggest gaps that we know internationally are used in grand corruption schemes. And these are issues that are quite significant and I think quite substantial vulnerabilities. And it's something that is not just in one particular section of the financial disclosure requirements. It is a principle that needs to be applied throughout. So in every section that you would have to speak to your beneficial interests, for example, when it relates to property, when it relates to companies, etc.
So we've now highlighted two blind spots of the form. In paragraph 19, you deal with specific categories of assets that the form doesn't ask for. And can you take us through those?
Sure. So
It's not just categories of assets, it's issues relating to assets.
that's correct. So in the current approach for each asset that you declare within a category, let me use the example of purchasing a house or owning a house. Within this particular category, there are 4 or 5 specific pieces of detail that you need to provide about this property. You would have to explain where it's located. You might have to explain what the value of the property is. But there are additional pieces of information that are really important for subsequent processes when we get to the stage of lifestyle reviews and investigations. So this additional information that one also needs to know is when was this property acquired? How was it acquired? What did you know, how much did it cost when you paid it? And so it's about more consistently being able to describe a full picture of your financial status, so that over time with these forms, we can see the changes, we can see a person disposed of this asset that freed up capital to purchase a new asset. And so it helps us understand what these changes look like with time, but also detect potential cases where somebody all of a sudden shows up with assets that have previously been undeclared, and you might have questions. Are these omissions from previous years? Or has this person now been able to buy a brand new house? Where has that money come from? Is it them that has paid for this house or car? Or is it potentially a gift that somebody might have given to them? So there are little bits of pieces of information like that consistently throughout the form are required to better understand the origins of these assets, to understand the context within which they were acquired, whether they were a gift, whether this is something that you bought, whether it's something that your spouse bought, for example.
Then moving on to the next category, which I anticipated, which is types of assets that fall outside the scope of the current form.
Sure. So within the current form, the focus is largely on some of the more common and I guess high value items that one might consider. So it includes things like vehicles, it includes companies, it includes property in the form of a house, for example. But I argue that there are several other common asset types that also need to be considered, and some of these can be quite important. And again, this is about building a full picture of not just a person's interests and assets, but their financial means. And this is one of the consistent narratives or themes that I want to point out to. Across the form, what we need to do and what we need to be able to do is understand the kind of flows of an individual's financial status, of what kind of wealth is coming in, where is it going, where is it being spent. So some of the assets that I mentioned that currently are outside of the scope of the form, this includes high-value movable property other than vehicles. So for example, things like jewelry, precious stones, livestock, and other similar high-value items that might hold quite significant value, but might not necessarily be disclosed and are not required to be disclosed. The second point is around virtual and intangible assets. And here I particularly mean cryptocurrencies or other kind of digital tokens that can often hold substantial value. And in many cases, this is an asset that is extraordinarily easy to transfer, both between individuals, across borders, and can hold a huge amount of value, and is not something that we would currently be considering in the framework. The third point that I make is around monetary assets. So here I mean cash on hand that you might have, say for example in a safe. It means your bank accounts, being able to, in your financial disclosure form, not just say I own 2 cars and a house, to say I own 2 cars, a house, and 2 million rand in a bank account, for example. Having that level of detail is important for understanding the origins of assets down the line, for understanding people's financial means when they acquire new assets. And so, again, this is part about understanding the full picture, understanding changes over time. And then I also raise a point around the form currently focuses on, it's a new section that was added, I believe, in the last amendment in 2023 that introduces a section where an individual must report any liabilities, so loans that they owe somebody. What you also need to understand is money that is potentially owed to an individual, so loans that they may have given out. So that's relevant both for the question of understanding a person's financial means, their sources of income, and what's happening there, but also what kind of relationships they might have to other actors and their associates. We might want to ask questions around why an individual is loaning potentially a large amount to somebody else, and what kind of obligations are tied to that, and what does that relationship look like practically.
Dr. Silman, how do these forms treat, it's a modern phenomenon where something is neither an asset nor a loan in the true sense, but a public official has the right of use of an asset, either a house or a car, that belongs to somebody else. How do the forms treat that? Because it's not a loan to you, it's not an asset registered in your name, it belongs to a shady third party who purchases it in their own name, but you have access and right to use it as and when you please. Do the forms deal with that, and how do they deal with it?
So it's an excellent question, and this relates to our definition of beneficial ownership. So it's not just about ownership, but as you say, about beneficial use, and making that clear. And so the way to approach this in your form, and this is much simpler in an electronic format, but for each asset that you declare, that you state, this is an asset that I own under my name individually, or that I have beneficial use of, I have beneficial control, or I have joint ownership maybe with my spouse, etc. And so this deals with that issue of beneficial use. And so with something like this, you'd have to very clearly establish what the requirements are. And this is why good guidance is important, why you need advisory services to advise people on how to prepare their forms so that they can ensure that they're preparing the forms correctly. But it's a fantastic example of why it's important to ensure that these requirements are as broad as possible so that people can fill out all kinds of interesting situations that they might find themselves in to ensure that we have a full picture of their circumstances, of their interests.
Because I can imagine a situation where a senior general in the SAPS drives a 3 million rand car, and then when it comes time to disclose, he says, well, it's not mine, so I don't have to disclose it. And there's nothing the SAPS can do about it because it's really not his car, it's his friend's car or somebody else's car, although it parks in his garage every day and he uses it every day.
That's exactly it. And I think that's a great example of why this current gap in requiring disclosure of beneficial ownership or beneficial interest is such an important one, because that official can entirely declare that they own 0 cars and they would be following the rules. There is nothing we can do about them, and it would be correct. But we know that there is another reality, there's a factual experience on the ground that differs from what is required.
The last category that you speak to is the way the form treats income in paragraph 21. Can you elaborate there?
Sure. So I've spoken to this a little bit in terms of how we need a kind of constant narrative throughout the financial disclosure form to understand the origins of each asset, when it was purchased, what its value was at purchase, but also in many cases when it was disposed of, because this is about understanding the individual's kind of flow of financial means and what this looks like over time. So when I speak about income here, we're not necessarily talking about this in the same way as an accounting practice of saying this was the revenue this year, this was the expenditure. We need to understand things like taking on a loan is a type of income, right? Because that extends to your financial means. And so having a consistent view of what money is coming in and where it's being spent, this then feeds into the downstream processes on the lifestyle reviews, on the audits, and understanding what kind of lifestyle somebody is living. So to speak to the question of beneficial ownership as well, and somebody potentially having a new vehicle or property showing up on their declaration, for us to be able to credibly question the origins of, say, a vehicle or a new piece of property, and whether an individual paid for that themselves, we would need to know whether they had that financial means to begin with. If this year, all of a sudden, they have a new property that they didn't declare last year, is it because they've disposed of some assets that has freed up cash? Is it because they have a large amount of money in a bank account that has been lying dormant, waiting to purchase this new asset? So again, it speaks to the kind of understanding of the kind of constant flow over time of income and expenditure. And so it's in part, it's reflective of the current approach that I criticize, that our current approach in the financial disclosure form is essentially a list of assets that one owns. It is not intended to understand these changes over time. It's not intended to understand the additional kind of interest that somebody might have. And so some of these changes that I propose, and this is based on good practice internationally, it's about strengthening the downstream processes, about having the necessary information available to detect potential anomalies and to support the kind of investigations that we need at a later stage.
Now, a question that sort of comes to my mind is, I can see the logic of everything that you're saying about the needs to improve the substantive content of the disclosure form, to have a disclosure form that will give you much more useful information. But one needs to strike a balance between the utility of the disclosure form and making disclosure requirements so onerous that they are incredibly difficult to comply with, and that I mean, in an extreme case, they may drive people away from the public service, but even in a limited sense, if you make a form so difficult to comply with, the capacity to say, well, I didn't actually understand, I had to do this or I had to do that, presents a defense when you start taking action on the basis of non-disclosures. What's your response to that?
Sure. And I think this is an important question. I think you do have to find a balance between kind of ease of use and ensuring that people can effectively comply with the requirements. But you also want to be as wide as possible to find cases of people engaging in conduct that they shouldn't and having interests that they shouldn't. And I think what we need to understand is when one is filling out these forms, in many cases, you wouldn't have much to report in all of these categories. I mentioned, for example, virtual currencies. Many public servants probably wouldn't have to worry about filling out that section of the form because they, for example, don't hold Bitcoin. And it might be the case in many of these sections. 80% of your public servants will probably only have to declare 2 or 3 categories of information. It would be your house, it would be your car, maybe your bank account if we extend it to that. And that is probably your average person. And I use the example often of thinking about when we submit our e-filing for SARS. There are, I don't know, 20 different forms of income that we can report. Most of us only have to do a few sources of income. And it's the exact same concept that in many cases, you wouldn't necessarily have to worry about all of these other categories of assets to declare or all of the complexities, because most individuals would have a very normal, very standard, straightforward profile. Where this really matters is the complex cases, is the difficult ones, where people are trying to engage in funny business, trying to get around the rules. And that's why it's important to have a form and disclosure requirements that are as broad as possible to ensure that the net is wide enough to capture those types of cases. But for most declarants, it would be a relatively straightforward process. And the next section speaks to the e-disclosure system and digitization. And one of the great advantages of digitization, even in the current e-disclosure system, an official, when you're preparing your declaration, you can import your submission from the previous year. So that already makes your life much more difficult. Unless you've had substantive changes, you've disposed of an asset, or you've had some kind of, significant windfall gains, your disclosure form would probably look very similar year from year. But what really matters is where you have those interesting cases of people that are the anomaly.
You said makes your situation much more difficult. I think you wanted to say makes your situation much more easy in relation to the e-disclosure form. You're just importing. So essentially, if I understand your evidence, what you're saying is that if a comprehensive form is introduced, in most cases, it's not going to affect public servants because most public servants have a very limited range of income and assets that need to be disclosed. It's important to have the complicated or the comprehensive form because you need to have enough information to catch people who are essentially making unlawful income and hiding it. There may be one or two, or there may be a limited class of people who have behaved perfectly legally, but may nevertheless find it a bit onerous to disclose all of their assets for reasons unrelated to corrupt income. But with an e-disclosure system, that's a once-off onerous, for the most part, that's a once-off onerous process. You'll just import everything thereafter, and it's only if there are dramatic movements in your assets and income that you need to disclose that it's going to be an ongoing problem, and those cases are going to be few and far between.
Yeah, I think that's exactly right. I think for most people, for most categories, you would just say nothing to declare, and you can move on to the next one. If you have this system where you can import information from the previous year, I mean, how many houses does a person buy in their lifetime? This is something that should be relatively consistent. And so extending the form to requirements like beneficial ownership, most civil servants, I imagine, are not engaged in situations where they have some kind of a complex legal structure to hide their financial interests or their company interests. And so something like that wouldn't necessarily impact most people substantively.
Can you then, we'll now get to the e-disclosure system, and can you take the Commission through what you say in paragraph 22, which explains what the system currently does, and then get to the deficiencies in the system.
Sure. So the e-disclosure system, in many ways, in its current form, is purely replicating what you would have on a paper form, but just in a digital format. You would have, in your regulations, you would find specific tables that say, for example, under immovable property, you would say, this is the address of my place, this is what the value is, etc. That would be exactly replicated in the digital space. And the challenge I argue with that is that there's a huge amount of untapped potential in using this as a data source for understanding how these assets interact with one another, for comparing across profiles. So, for example, one of the things that you can do with an e-disclosure type system, and this is something that is performed in other countries already, is to aggregate across all of the asset categories, to do that initial lifestyle review automatically, to be able to determine, it's a very straightforward algorithm. These are all the assets that have been mentioned. This is their value attached to them, and this is why the income and value questions are so important, so that you can build that initial financial profile. You can import a person's salary from the payroll system. You can have an automated system that determines whether this checks out. From year to year, you can have these kinds of comparison to say that we know last year this person didn't have a BMW. This year they have a BMW. Does that make sense in terms of what has been disclosed, knowing what their annual salary is? And so that kind of automation and kind of algorithmic risk analysis can do a lot of the initial legwork that we're currently relying on for ethics officers to do. And there's a huge potential to free up those resources and to rather focus your human resources on investigating the anomalies, the strange cases. And so I think there's a significant potential if we were to effectively change the approach of the e-disclosure system to think about all of this information as structured data, so that we can compare across years, we can compare across an individual profile, but also across categories of declarants. So for example, if you were to look at civil servants on level, say, 11, you would expect a relatively similar financial profile for most individuals. They earn the same amount. You maybe want to take into account how many years they've been at that level, or figures like that. But you would have, generally, most people would fall in a very similar bucket, similar financial circumstances. Within that context, if you find an individual that has, 2-3 times as much wealth as the person who works in the office next door to them, you might start raising questions like that. And something like this is potentially quite difficult to do manually. If you, as an ethics officer, are reviewing, say, 800 disclosure forms within your department, I doubt you would be able to remember everything and to manually be able to go through those forms and to make that kind of comparison. And so I think it's one of the important benefits of a digitized system that is currently unrealized. So one of the functionalities that the system has currently is its integration with the National Traffic Information System, the Companies and Intellectual Properties Commission for your company's data, and the Deeds Office for property. So it's an important starting point to be able to verify what a person has disclosed and what are on the official records, to determine whether the two of those add up, right? Currently, it's not automated, so this information is pulled into the e-disclosure system, and then the ethics officer themselves will have to look, the person declared this, on the official records we have this, and then determine whether this is correct. Again, this is something that can very easily be automated and immediately throw up red flags if there are these kind of discrepancies. Yeah, I think that covers most of the issues.
Can I just highlight one point that I think you made, but I just want to clarify I didn't misunderstand you. You said earlier that in the e-disclosure system, it will automatically populate all of the line items with your last year's disclosure. But if I understood you just now, you were saying what the system doesn't do is flag discrepancies between this year's disclosure and last year's disclosure. So it has the information, but it doesn't do the automated comparison.
That's my understanding, that's correct. So unless an ethics officer or an official from the Public Service Commission that's reviewing these declarations and doing the verification, unless they were to go to an individual's previous year's disclosure, the system wouldn't automatically pick that up. The only red flags that they currently have in the system is around other remunerative work and gift declarations. So the e-disclosure digital architecture includes a gift registry, and it includes a section where one would upload the documents showing that that their other remunerative work was approved. If the person mentions outside work on their financial disclosure form, the one type of verification, automated verification, that the system will do is to see whether a file is found within the register for other remunerative work. So the current system has very limited red flags, automated red flags, for detecting these kind of anomalies.
Then the next point that you make in relation to deficiencies in the current framework relating to disclosure is the absence of public access to financial disclosures. That's paragraph 24. Can you explain, can you explain the logic of your highlighting this point?
Sure. So I think one of the things we have to recognize in an open democratic society is that civil society is a fantastic resource for public accountability. And making these kinds of disclosures public has enormous potential to support the verification process. Currently, we're relying on individuals within line ministries to verify these disclosures. It's a very small cohort of individuals. But if one were to make these disclosures publicly available, immediately you have much more public interest. You have civil society organizations that would be supporting the verification process themselves. And this has the potential to turn up, for example, complaints. If I know my neighbor is a civil servant and every month I see them driving a new car, I can go look at their public disclosure form online, determine this seems a bit odd, and submit a formal complaint to somebody to say that maybe they should investigate this. So I think there are enormous benefits to public disclosure for broader kind of accountability and for supporting the verification of the system. In the current financial disclosure frameworks, so to speak, beyond the public service, currently members of parliament have their forms published publicly. I think it's a good example where we already see civil society taking that one step further. So currently, I believe it's the Parliamentary Monitoring Group that they themselves have distilled this information into a website so that you can see from year to year what a member of parliament disclosed. And that also creates a new kind of potential for civil society organizations themselves to develop, automated verification tools to be able to hold people accountable. And so the idea of public disclosure, it's not foreign in South Africa. It's something that we already do in isolated cases. In the local government framework, there is discretion to make financial disclosures public. And so evidently, this is something that would be possible within our legal framework. And I mention in the report, I mention 2 examples, and they're representative of the ways many countries do this. But I mentioned, for example, Ukraine that publishes the declarations for nearly 800,000 individuals. Now, can you imagine if a handful of ethics officers had to verify 800,000 declarations themselves? It would take an extraordinary amount of time. And using as I mentioned, leveraging the public more broadly to hold their neighbors accountable, for civil society organizations to look into these disclosures, we start outsourcing the kind of verification and start strengthening the verification measures. And it's not necessarily that you have to publish every detail of the financial disclosure form. So I mentioned here the example from Sri Lanka, from their Anti-Corruption Act that was recently adopted, where these disclosures are published in a redacted form. So you would say that they own a property in this city, for example, or they own this make of car, but you don't necessarily say the address, you don't say what the registration number of the car is, etc. So you can find a balance between public access and the individual's right to privacy. And the same applies when we speak to the issue of family members. So it is something that you'll see in many cases, that in cases where you require an individual to disclose the interests of their immediate family members as well, that those disclosures don't necessarily have to be made public, because that then respects the privacy of the individuals that are outside of the public service. But I think one of the common concerns around this is what does the legal framework for this look like, and whether you'd be violating the rights of a public servant, their right to privacy. But one of the things we have to understand, even POPI, the protection of information, of personal information and privacy, it recognizes that there are legitimate circumstances in which privacy can be restricted. And it specifically talks about corruption and corruption investigations. And in many countries, what they would do, it's part of your conditions of service that you have to abide to a certain code of conduct, to certain ethical requirements. And this kind of public disclosure would merely be part of those requirements as your conditions of service as a member of the civil service.
I actually wanted to ask a question that relates to privacy concerns, but in a slightly different context. You touch on it in the context of disclosures being made public. My question relates to the instance where disclosures would have, as you touched on this before, would have to be extended beyond the official consent. For example, even to family members. So I thought, before you touched on the privacy concerns, I actually thought of those, because even your immediate family members are not you, the official. So there would naturally be privacy concerns there. And I thought in South Africa there could possibly be constitutional issues around it. Not that this would necessarily not be surmountable. For example, we have Section 36 of the Constitution, which says there may be justification for the infringement of rights. But at the stage when you first introduce this, say through an act of Parliament, you may not know whether the courts will ultimately say that this is justifiable. I just thought of raising that and maybe find out whether you have some experience in other countries about what has happened in this regard?
I think that's an entirely fair question, but I think the way that you framed it, in terms of the constitutional requirements, it does recognize that there are instances in which these rights can be limited. And framing this within the context of your conditions of service as a member of the civil service, for example, or an individual working in the public sector, creates a limitation on the infringement of these rights to privacy. If we were to...
So I'm very sorry to interrupt you.
Yeah.
Your answer relates to the officials' conditions of service.
Yes.
The members of your immediate family are not employees, so this would not apply to them.
Yes, that's correct. And this is why I was saying in the Sri Lanka example that you often have redacted sections where you wouldn't extend this necessarily, the public disclosure requirements to family members that are outside of the public service to respect their right to privacy.
I'm talking even outside of public disclosure. I'm talking about, you remember, not criticize you, I would also not be able to venture an opinion as to what the courts might hold in this regard. Thank you very much for that.
Thank you.
May I just ask, having looked at the civil service or the public service in general, but also the SAPs in particular, is it a case of, are you aware whether there is conversation about making these disclosures public? And if there are such conversations, what has been identified as the constraints, why it's not happening?
I haven't yet come across a case where there is anybody within the government framework that is actively pushing for making these disclosures effort to introduce public disclosure.
But can I just clarify that you do make the point, first of all, that parliamentarians have to make public disclosure. So the declarations of parliamentarians are made public.
In some of the limited studies into this, it's not a function that, it's not something that many municipalities apply. And I think, for obvious reasons that they would be concerned around, disclosing these. I don't believe it extends to family members, but I stand under correction. I'm not as familiar with the requirements for members of parliament. I know the public service framework, and this is the same framework that applies to SAPs who've adopted the same requirements, but members of parliament I'm not as familiar with.
We can investigate that separately. Chair, we have some way to go, so
Yes.
we passed.
Yes.
We passed 11 o'clock long ago. Would it be a convenient time to break for tea?
Let's break now and come back at 11:40. Let's adjourn.
It's 11:39. We are ready to resume. Please make sure that your phones are on silent. Thank you.
Yes, Mr. Chatterton.
Thank you, Chair. Just a couple of, well, not one housekeeping matter. Over the break, we've printed out which show how many, which shows that we're just having problems with the display at the moment. Is that in relation to required disclosure of assets of family members in low-income countries, 38% of countries require such disclosure. In lower middle-income countries, 79%. In upper middle-income countries, the first is by region, and the second is, so if we look at the first table, figure 6.2, the higher income OECD family.
So it's 9 years.